Hello, welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest is Michael Malter. Michael is a bankruptcy attorney who is a partner in Bender and Malter, LLP, a boutique bankruptcy firm located in Santa Clara, and he has been practicing law for 34 years. Graduated with a JD degree from the University of Santa Clara School of Law in 1980. He is a certified specialist in bankruptcy law through the State Bar of California Board of Legal Specialization since 1995. Michael has been an adjunct faculty member at Santa Clara University School of Law since 1985, and he has been named a super lawyer of the U.S. and California by Thomson Reuters every year since that recognition was first awarded in 2004. He's a founder and first president of Congressman Don Edwards' Inn of Court, a chapter of American Inns of Court. He is a dad with two teenage daughters, and his outside interests include labradoodles and hiking. So Michael, thank you for joining me today.
My pleasure, Michael.
Okay. Today, Michael and I are going to be talking about what you should know about bankruptcy relating to individuals. And as we get started, I want to caution our viewers that bankruptcy is a complex area. You definitely need a lawyer. Probably the sooner you consult with a lawyer, the better. And we're just starting a conversation that we hope that you'll continue with your own attorney. Michael, you've been a bankruptcy attorney for 34 years. What sort of changes have you seen? And I think you've probably seen a lot of changes even in the last year.
Yeah, that's absolutely true. I think one of the biggest changes I've seen over time is just a change in kind of the makeup of my clientele. You know, in the old days, you'd think of somebody filing bankruptcy as the guy on the Monopoly board with the pockets turned inside out, you know, the kind of sad character. And stereotypically, in days gone by, you would think of somebody who's really down and out in filing bankruptcy. But over the course of the 34 years, I've seen in time, my clientele has been every aspect of society. I've represented doctors, lawyers, Indian chiefs, all walks of life in bankruptcy proceedings because of a number of factors. But it's no longer just someone who's a deadbeat or somebody who just is unwilling to pay bills.
Mm-hmm. Okay. So why do you think that it is the case that you've got a broader spectrum of people that are having to do bankruptcy consultation with you?
Well, because I think that some of the precipitating factors for filing bankruptcy are true across the board. If an individual, for example, is suffering from unemployment, and that could be somebody at a low end or a high end of the economic scale, unemployment is devastating and unfortunately will mean a buildup of debt. Divorce is an unfortunate frequent cause of bankruptcy filings. I remember being told that divorce and bankruptcy are the soup and salad of law, and there's a little bit of truth to that, and it doesn't matter where you are on the economic scale. It's certainly been true in the last several years with the Great Recession, with the real estate debacle. There were very bright, very sophisticated people who made unfortunate investments in the early 2000s, which just crashed in the later 2000s. And they needed relief. And that's what the bankruptcy code is all about, providing relief.
Okay. So what are some warning signs that someone should think about consulting with a bankruptcy attorney?
Well, the first is if one's expenses are exceeding their income. There's obviously a need to do some planning. Whether that's simply financial planning or something more drastic like a bankruptcy filing is to be looked at. Looking at, for example, the interest rates that one is paying on their debt. If you're paying very high interest rates, especially at a time when interest rates have really come down so significantly, then there's an issue. As mentioned before, divorce sometimes will instigate bankruptcy filing. When you're splitting a pie in half, it becomes very difficult financially for both of the spouses. And sometimes if the arena of debt can be removed, it's going to make for a simpler and more streamlined divorce. Yet another factor is litigation. Anyone who's had the misfortune of being involved in a lawsuit knows that they are very, very expensive. They're a tremendous financial drain. And sometimes the only way to stop that lawsuit is going to be with a bankruptcy filing.
Now you mentioned the credit card thing. I've extended to the credit card. You were talking about interest rates. When you talk interest rates, I think of credit cards. And part of what's happened in our culture, I think, is that maybe too many people have gotten into the, well, I'm juggling and I'll make that minimum payment. And the next thing you know, you're paying 18% interest, and maybe the environment isn't really an 18% environment, and maybe you just need to look into restructuring your debt, maybe getting some sort of a loan or refinancing your home. So do you advise people related to stuff like that? Or?
Yes, absolutely. First of all, credit cards are quicksand. And we all know that done right, you pay your credit card in full each month. Mm-hmm. That's how you win, as opposed to the banks winning by the interest. But unfortunately, many of us are extended on our credit card debt. I've seen very, very large balances. It's not unusual to meet with individuals with $50, $100, even $150,000 in credit card debt is not astonishing. And then when you compound the interest, of course, it's just absolutely awful. In what we had seen is over years gone by, very often because of the rapid appreciation of real estate in California, folks were able to get lines of credit or loans against their home to then retire the credit card debt. But that's really only starting to happen again. We went through 5 or 6 years here where lines of credit were frozen, people couldn't borrow against their house, and so that alternative just vanished.
Yeah, and then banks became tight in general, as I understand it. Even let's say if you wanted to get an unsecured credit line, I can tell you that. I had a nice credit line, and the bank said, okay, well, you have a choice. You're going to have one that has worse terms, or, you can keep the terms for this one and just pay it off over time.
Well,
that's what I did.
We know when the pendulum swings, it often goes, very far in either direction. And it is absolutely true, Michael, that we've gone from a situation of lenders giving out dollars for no cash down, with no credit worthiness. That was part of the problem with the Great Recession.
Right.
The pendulum has now swung so that even those with sterling credit and those with a lot of equity and houses are really having a tough time borrowing. The banks have really tightened up on the money a great deal.
Yeah. Okay. Why does it make sense to see a bankruptcy attorney early?
Well, very often there may be planning involved before a bankruptcy filing. As a practitioner for 34 years, one of my biggest concerns, it's very easy to file a bankruptcy. I could, if I had time and patience, I could probably teach one of my dogs how to file a bankruptcy. But the key really is to looking at life after bankruptcy and to make sure that the individual is going to be able to get on with their life, enjoy a decent quality of life. And very often that means taking steps before the bankruptcy is filed. And those are steps to ensure an ability to obtain new credit after bankruptcy filing, to try to retain some credit. This becomes very, very important for life after bankruptcy. And so the sooner that the individual can meet with counsel and start devising a plan, the better.
Okay. What are the different bankruptcy chapters that apply for individuals, and some of the advantages, disadvantages of each?
Well, for individuals, there are three different types of bankruptcies, and these are referred to as Chapter 7, Chapter 11, Chapter 13. First of all, by way of demystification, bankruptcy law is a book. It's called the Bankruptcy Code. It's federal law, so it's the same law whether we were here in San Jose, California, or Teaneck, New Jersey. It's the same law. But the Bankruptcy Code is a book with chapters. One chapter is Chapter 7. Another is Chapter 11, and another is Chapter 13. In a Chapter 7 filing, the goal is to simply wipe the slate clean and to get a fresh start. And that's the phrase you hear over and over again. Chapter 7 is about a fresh start. And so in Chapter 7, we're going to look at the types of debt which are owed to see if it's the type of debt that can be wiped out or discharged. And we're going to also look at assets to make sure that all of the assets are going to be protected. So in an ideal Chapter 7, in order to get the freshest of fresh starts, all of the debt is wiped out, all assets are retained. Now, it's not always that perfect a case when we go into Chapter 7, but we want to get as close to that ideal as possible. If the individual has debt that can't be wiped out in Chapter 7 or might lose assets in Chapter 7, the typical alternative for the individual is going to be a type of bankruptcy called Chapter 13. Chapter 13 is a form of a payment plan with the force of the federal government behind it. In a Chapter 13, the individual makes a single payment each month to someone called a trustee. The trustee takes that payment and then divides it out among the creditors. One of the great things about Chapter 13, which is a 5-year plan, by the way, one of the great things about it is that with the filing of the Chapter 13, the interest stops on all of the debt. And so basically, if the debt going into the Chapter 13 is $30,000, that's how much will be paid. It's not 30 plus God knows how much in interest and penalties. It's a fixed amount. And finally, the amount paid is based on the individual's ability to pay. So that sometimes the best an individual can do is pay, for example, 10% of what they owe. So if someone owes $100,000, but the most they can pay over 5 years is $10,000, that may be approved by the court. And of course, that would be a 10% Chapter 13. The last type of bankruptcy available to individuals is called Chapter 11. This is the least utilized of the bankruptcy proceedings for individuals. Chapter 11 really was designed for mega corporations, the PG&E, Enron, Macy's, American Airlines. But it is available for individuals, and there is a limit as to how much someone can owe and file for Chapter 13. So if their general unsecured debt, like credit card debt, general loans, etc., is greater than $360,000, they can't file Chapter 13. If their secured debt, like their mortgage debt, debt against real estate, cars, etc., is greater than $1.1 million, they can't file for Chapter 13. So there are those situations in which Chapter 11 becomes the only vehicle for the individual. For example, I've represented individuals who have owned a large amount of real estate. They have real estate worth millions of dollars, and there's millions of dollars of debt against them. In that situation, Chapter 11 might make sense. But Chapter 11 is vastly more expensive than Chapter 13. And it truly is a last resort for the individual.
So is Chapter 7 then the most common for individuals?
Yes, it is.
Okay. Yeah, okay.
Chapter 7 also, Michael, is typically start to finish. Chapter 7 takes about 3 months from the filing of the case till the conclusion in the bankruptcy court, assuming that there are no hiccups, no problems. Chapter 13 is a 5-year plan. You're in a bankruptcy for 5 years. So if either option was available to an individual, I personally would counsel Chapter 7 if they could do so. and speed up the ability to get that fresh start that Chapter 7 is all about.
So you can sort of get on with your life and
That's correct.
behind you. Okay.
Right.
I've heard that the bankruptcy rules were changed, I guess it was about 2005, to protect credit card companies. How were they changed? How does that affect an individual's eligibility for bankruptcy protection?
Well, the significant change in 2005 was that there were determinations set up as to who can and who can't file Chapter 7. So it really was just as of 2005, rather, that the question of how much the individual earned came into play. If an individual earns any kind of a decent wage, they may very well be forced to do a repayment plan like a Chapter 13. They may not be eligible to file Chapter 7. So the big change in the law was to try to promote repayment as opposed to just a across-the-board discharge of all debt.
So they did make Chapter 7 a little more difficult, particularly for people who were still working and had a pretty decent income.
That's absolutely right. The changes were from the credit card lobby, were from the banking lobby, and frankly, we look here in Silicon Valley, and there is nothing hard and set that says if you earn more than $50,000 you can't do Chapter 7. It's based on looking at income and expenses. But the truth of the matter is that if somebody earns $50,000 or $60,000, they very well may not qualify for Chapter 7. Whereas we know, living in Silicon Valley, that if you're earning $50,000 or $60,000, you're probably struggling to get by.
Yeah, that's subsistence living here.
Yes.
It's kind of a tough situation. Okay, well, how is the eligibility for bankruptcy determined?
Well, it is a view of income. It's also a view towards income versus expenses, so looking at one's monthly budget. If it appears that there's a surplus of income over expenses, then the individual may very well be required to do a payment plan like a Chapter 13. One exception to that is if the majority of the debt owed is business related.
Okay.
So if the individual has had a failed business, for example, and let's say they had to guarantee a lot of the debt of the business, they may automatically qualify for Chapter 7. Whereas if the majority of the debt is consumer debt, such as credit card debt or home mortgages, then there's going to be this test as to whether or not the individual should instead be doing a payment plan. That test is called the means test, and is a very complex and confusing test to determine whether individuals qualify for Chapter 7.
Okay. Now, you were talking about business debt. How does this play in for like real estate investors? Does this help them out too?
Yes. Actually, that's a good question, because I had a number of individuals during the real estate downturn who did qualify for Chapter 7, even though they may have earned a decent income because of failed real estate investments. Those failed investments where there were large deficiencies on foreclosed real estate very often immediately qualified those individuals for Chapter 7.
Okay. Okay, this may relate more to people in the not too distant past, but it may still apply for some, especially if we have people that watch maybe from the Central Valley. Why should you consult with a bankruptcy attorney before going ahead with a short sale?
Well, short sales, which were certainly all the rage a blink of an eye ago, and are still happening to some degree. Short sales sometimes are, how can I say this, sold by real estate professionals as a nice, clean, harmless way of getting out of a bad real estate situation. In fact, there can be many repercussions to a short sale. One of them that I know you're very familiar with, there can be very grave tax consequences to short sale. So one consideration is certainly the tax consequences, and I want to bring a Michael Gray in to advise on that. Second of all is sometimes the homeowner or the property owner would assume that with the short sale, junior mortgages behind whoever did the short sale would just go away and leave them alone, and that was not always the case. And so there should have been negotiation in regard to the construct of those short sales to make sure that once the sale was complete, those lenders, in fact, were never to be heard from again.
Okay. How are obligations for real estate different from other debt?
Well, first of all, in regard to real estate, the mortgages, so that, for example, the first deed of trust or the primary mortgage is not wiped out in bankruptcy. If you were able to wipe out mortgage debt in bankruptcy, every American would file bankruptcy by 5 o'clock today. So it's especially the senior mortgage debt is not going to be affected. What was very interesting over the last few years when the value of real estate really plummeted, there is an availability in some types of bankruptcy, those types being Chapter 13 and Chapter 11, to remove junior deeds off of a piece of real estate if there's no equity to cover them. So that if, for example, I have an investment property that's worth $300,000 and there's a first mortgage against it for $305,000 and a second mortgage against it for $60,000, if I file Chapter 13 or Chapter 11, I may be able to pull that $60,000 mortgage off of the property because there's no value for it to attach to.
So in essence, you're converting it to an unsecured debt.
That's exactly what you're doing.
Yeah.
And the view is, because it is unsecured, because there's no real collateral to cover it. It's still true in parts of California where real estate has not fully recovered, but less true in our immediate area.
Right. So we're in Silicon Valley, of course, and real estate is hot here again. So it's kind of crazy.
It's just the opposite. Yeah, there's not a lot of junior lien stripping going on right now.
Okay. Do you have a choice about whether to keep your real estate when you file for bankruptcy?
Very often you do. Especially to the extent there's not a lot of equity in your real estate. Now, in California, we enjoy something called the homestead. The homestead protects a certain dollar amount of equity in your real estate. For an individual, it protects $75,000 of equity. For a couple or a household, it protects $100,000. If the individual is over 65 or disabled, it protects $175,000 of equity in the real estate. So if you file Chapter 7 and your equity is not greater than those levels, the bankruptcy court has no interest in your real estate. If, however, the equity is above those amounts, then I would not advise the individual to file Chapter 7. I would suggest they look to one of the other forms of bankruptcy, a reorganization.
Okay. Well, we've got a few minutes left, Mike. Maybe you'd like to share some words of wisdom for individuals that are thinking about, okay, you've got about 4 minutes, about whether they should go ahead with bankruptcy or maybe even should they go and consult with an attorney and so forth about this.
Well, I think that it's certainly a meaningful discussion to be had. My office is not alone in the fact that we do not charge for initial consultation. If someone is struggling with debts, talking to a professional and seeing if there is relief available, relief that you can live with, I think makes a lot of sense. A lot of us grew up with, the bankruptcy code changed dramatically in 1979. Bankruptcy law essentially stayed the same between 1845 and 1979. That's a long period of time.
Yeah, that is a long time.
And during that time, there was great trauma and great stigma associated with bankruptcy. That changed in 1979. So when I would speak of bankruptcy to my folks who were raised during the Depression, They thought of bankruptcy as a quick ticket to a leper colony. They thought it was the worst thing in the world. But the change in law, frankly, made it a more palatable alternative. And I think that what my clients see is that life after the bankruptcy looks no different than life before, except perhaps a lot of stress relief. Mm-hmm. And debt stress can affect individuals, can affect one's health. It can be a horrible detrimental factor to marriages, to families. And in a world in which we can't relieve all of the stress in our lives, if there's an area where we can relieve some stress, I think it's worth taking a look at and paying a visit to a qualified bankruptcy professional.
Right. And as we said, it may be that, that an attorney or maybe even a credit counselor can help to point the way to take care of some of these issues without having to go through bankruptcy.
That's correct. But like everything else, it's important to be smart consumers. Mm-hmm. And if dealing with a financial counselor, check out who that counselor is, make sure they're reputable. There are great agencies like Consumer Credit Counseling is a nonprofit agency. It's been around forever. Mm-hmm. Likewise, you want to go see an attorney who really knows bankruptcy. Mm-hmm. I don't know how to do a will or a trust or a divorce, but I've been doing bankruptcy for 34 years, so I'm pretty good at it.
Okay.
And making sure that you're with the right professional is extremely important, because this is a terribly important decision for any individual to make.
Okay. Mike, I want to thank you again for joining me, sharing this very important information. Folks, I know that there are some people that unfortunately are facing, financial challenges. And so there are people like Michael around that are here to help you. Take advantage of them. We'll see you next time on Financial Insider Weekly.